Hello. Sige. Good. Good afternoon, everyone. So, forgive me for this delayed video because I just get out from the hospital. Parang medyo mahina-hina pa ako. Nonetheless, I hope you can find this video and learn from it, as we have no more time for your incoming prelim exam. So I just get out really from the hospital. Sige. So we'll continue with our lecture. With this video, we'll finish the whole topic for the prelims. Okay? Sige. For the first article 1459, the thing, meaning the determinate thing in a sale, must be licit. Okay? Diyan muna tayo. When we say licit, licit, or in other words, it must be licit or it must be legal. So, dapat yung binibenta mo na object ng isang contract of sale or any sale thereof should be legal. Meaning, if it's an illicit thing or illegal, therefore the sale will be void. Okay? So, ano yung mga void sale? Sale of animals suffering from contagious disease, sale of future inheritance, precisely because it's not yet your property, sale of lands to alien, because aliens, when we say aliens, hindi yung alien yan yung mga foreigners. When we talk of aliens, they are foreigners. Okay? Meaning foreigners cannot legally own or foreigners cannot legally own land in the Philippines. Okay, so ang point lang dito is that the determinate thing must be legal. Okay, if it's not legal or not licit, it will be a void sale. The second thing under this article, the vendor must have a right to transfer the ownership thereof at the time it is delivered. Take note, it pertains to the vendor, meaning si vendor must have a right to transfer the ownership. This pertains to the thing again. So dapat si vendor may right to transfer the ownership of the thing at the time it is delivered. Take note, guys, at the time it is delivered. Meaning that, let's say for example, I have a friend, paano ba? I have a friend who's selling me cellphone na lang, para madaling example, who's selling me cellphone for a price of 8,000. Okay? So, ako naman, naisip ko, pwede kong ibenta ito ng mas mahal. Therefore, ako naman, binentay ko itong hindi ko pa ito binibili, okay? Hindi ko pa siya binibili. So, parang i-offer ko muna sa iba, i-offer it to other persons at the price of 10,000 pesos. So, kapag meron nag-agree sa akin na gustong bilhin yun, at the time of the perfection of the contract, I am not yet the owner. I do not have yet the right to transfer the ownership. Okay? Is that okay? Yes, that is okay. And the sale may be perfected in that sense. Okay? Ngayon, at the time na kunwari, sabihin namin after 3 days mag-exchange na kami yung cellphone tsaka yung pera, dapat at the time of delivery, dapat nabili ko na kay friend ko yung cellphone. Okay? So parang ganun siya. The vendor need not necessarily be the owner. The vendor need not necessarily be the owner or does not necessarily have the right to transfer ownership at the time of perfection. Ano lang ang dapat? Dapat the vendor must be the owner or must have the right to transfer ownership at the time of delivery. Okay? At the time of delivery, hindi at the time of perfection. Okay? So I hope that is clear. In this example, we have X, Y, and Z appointed C as their agent to sell 3 parcels of land adjoining each other. E purchased all 3 parcels of land and asked that C, yung agent daw, ang gawing vendee. After some time, C, the agent, kung sino yung pinangalan na vendee, without knowledge and consent of E, si E yung totoong bumili ng lupa, sold 1 parcel to R. R was aware that the land was owned by E, not C. May R acquire ownership over the wait lang guys. May R acquire ownership over the property. Okay? Ito X, Y, and Z nagbenta sila kay E. Si E pinangalan, imbes na kay E daw ipangalan, ang sabi ni E, ipangalan niya na lang kay C. Ngayon itong si C, binenta niya kay R. May R acquire ownership. Now R is aware of the fact that the E was the one who owns the property. The answer is here is no. R may not acquire ownership over the property. Ayan. Since C did not have the right to transfer ownership thereof, whether R is in good faith is immaterial. C is merely trustee thereof and could not have transferred the ownership of the land. A person can transfer ownership by way of sale of something over which he has. A person cannot transfer ownership by way of sale of something over which he has no right to transfer. So, take note from that example. Okay? Ang totoong may-ari ito, si E. Siya ang totoong may-ari. Okay? Si C naman, siya sa kanya lang pinangalan. Pero hindi siya talaga yung may-ari. Okay? Ngayon, binenta niya kay R. C cannot transfer ownership mainly because C is not the owner. Okay? That's your main argument. Okay? How can one transfer ownership if at the time of delivery, he is not the owner? Okay? Take note the vendor may not be the owner at the time of perfection. Pwede lang yan. But the vendor must be the owner at the time of delivery or must have the right to transfer ownership at the time of delivery. Okay? We'll pick up the pace kasi hindi ko kakayanin. The seller need not be the owner at the same time. The seller need not be the owner at the time of perfection of the contract. Diba? Sinasabi natin kanina, the seller need not be the owner at the time of the perfection of the contract. Hindi niya kailangan maging owner. Okay? It is sufficient that he is the owner. It is sufficient that the vendor is the owner at the time of delivery. Ayan yung main point. Okay? Otherwise, you may be held liable for breach of warranty against eviction. We'll tackle warranty against eviction further. Hindi tayo mag-focus dyan during these prelims. So, yan lang muna ang kailangan tandaan, that the vendor need not be the owner at the time of the perfection of the contract. Perfection meaning at the time that the buyer and the seller agreed, kahit hindi pa si vendor ang may-ari. But at the time of the delivery of the property, dapat si vendor na ang may-ari or si vendor na ang may right na mag-transfer ng property. Okay? We have discussed this pasak pa nahapyawan na natin ito before. Okay, nahapyawan ko dun sa main article noon. We'll just substantiate, but I think I've discussed this one enough kasi. Okay, like for example, this one, Article 1460. A thing is determinate. We have already discussed this one. When do we say that a thing is determinate? When it is particularly designated or physically segregated from all others of the same class. Diba? Pag nakahiwalay siya. Pag naka-identify siya, pag meron siyang description. Okay, that will segregate him or separate him from others of the same class. Okay, the requisite that a thing be determinate is satisfied if at the time the contract is entered into, the thing is capable of being made determinate without the necessity of a new or further agreement between the parties. This one we also have discussed. Remember our example on the bodega. Yan yun. Okay? Kaya nito, paano siya maging my only car? If you only have one car and you're selling your only car, then there's no other car that you can sell but your only car. Your only laptop that you are using at present. Your house located at number 4, Lagawa, La Trinidad. Okay? You may have a lot of house but you only have one house located in number 4, very specified, Lagawa, La Trinidad. Okay, so those will determine whether a thing is determinate or not. How about this one? C was the owner of lot 261. Let's say, for example, lot 261 is more or less 10,000 square meters. 10,000 square meters yan. C entered into a contract for legal services with attorney B, denominated as contract of attorney's fees. So this problem pertains about contract of attorney's fees. That I, C, is the registered owner of lot 261 and secured legal services of attorney B to perform the following, yung mga legal services. And sa bottom line, that for in consideration of this undertaking, I bind myself to pay attorney B 5,000 square meters of the said lot. Take note, it's worth the total area is 10,000. Okay? But yung ang nasa contract of attorney's fees is 5,000 square meters. Is there an object in the contract? Okay. What are we pertaining about? We're pertaining about lot 261. Okay? Lot 261, there is an object. Okay? How much of lot 261? 5,000 square meters. Take note, pag lupa kasi yan, dapat nakadetermine yung meets and bounds ng lupa. Diba? Para ma-identify mo. Say for example, this is the whole lot. Para ma-identify mo kung saan sa lupa ang nabenta mo. Doon mo siya masasabing determinate. Okay? But in this case, the Supreme Court said that it is already a determinate object. Why? Because basta out of the 10,000 square meters, basta 5,000 dyan is kay attorney B by virtue of the contract of attorney's fees. Okay, that is already considered as a determinate object. The object of the contract is still certain. The object of the contract is the 5,000 square meters of lot 261. Diba? Failure of the parties to state the exact location is of no moment. Does not indicate absence of principal objector under the contract point. As long as out of the 10,000, 5,000 kay attorney B, then that is okay. Okay? Things having a potential existence may be the object of the contract of sale. So take note, if a thing has a potential existence, it may be the object of sale. Okay? The efficacy of the sale of a mere hope or expectancy is deemed subject to the condition that the things will come into existence. In short, a sale of mere hope or expectancy, okay, may be valid. Okay, same as number 1. But the sale of a vain hope, or expectancy, meaning you're hoping in vain, parang wala kang pag-asa, binibenta sa'yo, walang pag-asa manalo. Okay, that is void. Okay, that is void. Okay? Yung things having potential existence, still growing fruits, wine that the vineyard is expected to produce, young of animals, not yet in existence. Take note, these are objects that have potential existence. Therefore, they may be the subject of a contract of sale. So, pwede silang maging subject ng isang contract of sale. Okay? How about mere hope or expectancy? Yan. Sale of lotto or sweepstake ticket. It may not guarantee you a win, but what is being sold is that hope or that expectancy or that chance to win. Yun ang binibenta mo dyan. Yung object mo dyan is the hope or the expectancy itself. Hindi yung reward or yung mapapanalunan mo, but the hope or the expectancy itself. Okay, when we say things with potential existence, other name dyan is emsho, res, sperte. Okay, when we say a mere hope or expectation, emsho, spe. Okay, so there is a difference. When we talk about emsho, res, sperte, it is a thing with potential existence, while emsho, spe is the hope or the expectation or the sale of a hope or expectation. For emsho, res, sperte, subject to the condition that the thing will exist. If it does not, there is no contract. Meaning, let's say for example, gaya nung sale of a young young animal, young of an animal, siguro nandun pa sa sinapupunan. Okay? If, let's say for example, goat na binenta kasama ng mga anak. Okay? Yan. Binenta kasama nung anak sa loob ng tiyan. Okay? The sale may be valid. Okay? The sale may be valid. Kasi kasama yung the goat itself. Pero kung ibenta mo is ito lang, itong young lang na unborn. Okay? If mabuhay itong unborn na to at ultimately mapanganak, then the sale is valid. If later on namatay, walang nabuhay, then there is no contract of sale to speak of. Why? Because take note, it has only a potential existence. It never did really exist kung namatay siya. Therefore, walang bayaran kasi walang nabenta. Common sense, logic. Okay? Sale is effective even if the thing does not come into existence unless it is a vain hope or existence. That is the difference between potential existence and hope. Dito naman, whether mag-materialize or hindi, mayroong contract of sale. Okay? Unlike sa potential existence, if it will not exist, then there is no contract of sale. Okay? Dito sa hope, ang binenta mo is yung hope or yung expectation or yung chance to win in a lotto or sweepstake. Yan ang binenta mo. Okay? Therefore, merong contract of sale dyan. Dito kasi sa potential existence, it may or may not exist. If it will exist, there's a contract of sale. If it will not exist, there's no contract of sale. Okay? And the last thing is, as to object, ito kasi ang object kasi na emsho, res, sperte is a future thing that has a potential existence. Therefore, there will be two possibilities. Whether it will exist or whether it will not exist. Okay? If it will not exist, there is no contract of sale. If it will exist, there is a contract of sale. Dito naman, the object is not a future thing but a present thing. What is the object? It's the hope, the expectation, or the chance. Yan yung object mo, hindi yung reward. Okay? Article 1462. The goods which form the subject of a contract of sale may either be existing goods. Of course, there's no more question with that. If it's existing, you can sell it. Okay, as long as it is owned or possessed by the seller. Or goods to be manufactured. Existings. So therefore, ang goods may either be existing. There may be goods to be manufactured, raised, or acquired by the seller after the perfection of the contract of sale. They shall be called future goods. Okay? So there are two kinds here. We have the existing goods and the future goods. Existing goods, wala ka naman ng tanong dyan. They are existing. Therefore, you can sell it. Future goods, goods that are to be manufactured, to be raised, or acquired by the seller after the perfection of the contract, they are future goods. Paano? Gaya nung sabi ko kanina, di ba? Take note, the vendor need not be the owner at the time of perfection. Di ba? But he must be the owner or must have the right to deliver at the time of delivery. Okay? Dapat siya yung may-ari or may karapatang maglipat ng pag-aari at the time of delivery. Okay? There may be a contract of sale whose acquisition by the seller depends upon a contingency which may or may not happen. What do we talk about? What do we mean about contingency? Let's say, for example, this example. F obliged himself to deliver and transfer ownership of his only car to S. This is the contingency. If the latter will pass the CPA board exam next month. Okay, that's the contingency. Meaning, if S will pass the CPA board exam, then F is obligated to transfer ownership to S. But if S will not pass the CPA board exam, then F has no obligation to deliver the ownership to S. Okay? So, ito yung sinasabi natin na there may be a contract of sale of goods whose acquisition by the seller depends upon contingency, which may or may not happen. Article 1463, the sole owner of a thing may sell an undivided interest therein. How do we do this one? Let's say, for example, this example. B owns a parcel of land. So the thing is a parcel of land, lupa. Okay? With an area of 400 square meters. Of course, the title of the lot is indicated there, 400 square meters. If B decides to sell 100 square meters to C, then they will become co-owners. Okay? Because this one, hindi mo kasi pwedeng hatiin yung lupa. Okay? Although, sir, hindi mo pwedeng hatiin yung lupa. Pwede ka magbakod dyan. Let's say, for example, 1, 2, 3, 400 square meters yan. Say, for example, ito yung 100 square meters. Pwede mo makuran yan. Pero yung titulo nitong buo, isa lang title niyan eh. Hindi siya pwedeng ma-divide. Okay? Unless there is a contract of sale. Sinasabi dito, the sole owner may sell an undivided interest in anything. Okay? Bayan yan. His interest in the whole lot is this 100%, pero ang binenta lang sa'yo is undivided interest or konti lang na part doon, then that is okay. Okay? Kasi there are properties that cannot be divided. Like for example, this one, lupa. And then, meron pa, building. You cannot sell the first floor of a building. You cannot sell the second and then you keep the first and the third and the fourth. No, you cannot. Okay? That's an undivided interest. Okay? Article 1464. In the case of fungible goods, there may be a sale of undivided share of a specific mass, though the seller purports to sell and the buyer to buy a definite number, weight, or measure of the goods in the mass, and though the number, weight, or measure of the goods in the mass, is undetermined. By such a sale, the buyer becomes owner in common of such a share of the mass as the number, weight, or measure both bear to the number, weight, or measure of the mass. If the mass contains less than the number, weight, or measure both, the buyer becomes the owner of the whole mass, and the seller is bound to make good the deficiency from goods of the same kind and quality unless a contrary intention appears. Titotorney, may naintindihan ba ako dun? Wala. Meron ba? Wala. Okay. Ang sinasabi lang dito, if you are an owner of a fungible goods and you decided to sell undivided share of specific mass. Let's say, for example, I have a bodega of palay. It contains sacks of palay. Okay? Let's say, for example, I sold 100 sacks of palay in my bodega. Okay? If I own 300 sacks of palay in all, then the buyer and the seller, or ako tsaka yung pinagbentahan ko, shall become owners in common, or we shall be co-owners. Okay, why? Because since I have 300 sacks all in all, therefore, yung 100 sacks magiging pagmamay-ari ni buyer, yung 200 sa akin. Okay? Ganun yung first paragraph niya hanggang sa first part ng second sentence. Okay? But if, let's say for example, having that same example, I sold 100 sacks. Same facts. 100 sacks in a bodega. Pero instead of 300 sacks pala, I only have 90 sacks pala sa aking bodega. What will happen? Okay? Therefore, the buyer will own the whole 90 sacks. Okay? Sabi niya dito, the buyer becomes the owner of the whole mass. Siya nang may-ari nitong buong sako sa bodega. 90 sacks. Plus, or in addition, I, as the seller, will also have to make good of the deficiency. Sabi nito, and the seller is bound to make good the deficiency from goods of the same kind and quality. Ibig sabihin, I must fulfill my end of the contract kasi ang sabi ko 100 sacks pero 90 lang. Kung hindi ko yan fulfill, kakasuhan ako. I have to add 10 sacks of palay. Yan yung 1464. Ayan yung example. S is engaged in a buy and sell business of rice. He owns a bodega with undetermined sacks of rice. Subsequently, B buys 100 sacks. If there are 300 sacks of rice stored in the bodega, then, since pasok na pasok yung 100 sa 300, then S and B will be co-owners. S owns 200 and B will own 100. So, there is co-ownership. S and B will become co-owners. But, if there are 95 sacks of rice in the bodega instead of 300, okay, 100 yung binili ni B, tapos 95 lang pala yung yung nasa bodega. S will be liable for additional of 5 sacks of rice. Okay, so that is 5 minutes lang. 5 sacks of rice ang idadagdag ko pa. Take note, the seller has the obligation to deliver, diba? To transfer and deliver the ownership of the thing. Okay? Kung pinangako mo 100 sacks, you give 100 sacks. Okay? Magdagdag ka pa ng 5 na sacks. Okay? Ganun lang naman yun. Kung sumobra yung sacks niya dun sa bodega niya, di kukunin na ni B yung lahat ng 100 sacks. Ganun lang siya. Things subject to a resolutory condition may be the object of the contract of sale. What do you mean by that? What do you mean by the term resolutory condition or subject to a resolutory condition? When we say resolutory condition, upon fulfillment, terminates an already enforceable obligation and entitles the parties to be restored to their original position. A resolutory condition is a conditional obligation that may be immediately enforced but will come to an end when an uncertain event that is specified occurs. Meaning, the obligation becomes immediately enforceable, but by virtue of the happening of a resolutory condition, okay, it will terminate this immediately enforceable obligation. Okay? Example, S and B entered into contract of sale with right to repurchase. Okay, right to repurchase, ang ibig sabihin niyan, let's say for example, si seller and B entered into, S and B entered into contract of seller and buyer, sabihin mo na yan. Ang ibig sabihin ng right to repurchase, S, upon selling the property to B, has a right to repurchase within a certain number of period the property. Parang right to redeem or right to buy back the property. Okay? Kapag in-exercise to ni S, okay, even if na-transfer na kay B yung property, mateterminate yung obligation. Okay, yun yung sinasabi nating resolutory condition. Even if it is already an enforceable obligation, but by the happening of a certain condition, it will be immediately terminated. Yun ang sabi ng libro ng Article 1465. Okay? 1466, in construing a contract containing provisions, characteristics of both the contract of sale and the contract of agency to sell, the essential clauses of the whole instrument shall be considered. Yung tinatanong lang dito kasi is in construing a contract containing provisions which have the characteristic of a contract of sale or an agency to sell, the whole instrument shall be considered. When we talk about construing, or when we say construe kasi to construe or to interpret the contract, it is really, if babalikan nyo obligations and contracts nyo, meron din dyan yung interpretation, and it is preferred that the whole instrument must be written in its entirety and not just the certain provision. Let's say for example, in a contract merong mga provisions, may mga sections sa isang memorandum of agreement or contract or deed of sale. It is better to read the instrument as a whole rather than by reading it in a provision. Okay? Or reading it per article or reading it per section or term. Okay? Dapat whole instrument. Anong difference ng contract of sale at contract of agency to sell? When we talk about contract of sale, of course, the buyer receives the goods as the owner. plainly a contract of sale. Pero kapag agency to sell yan, yung magre-receive ng goods hindi si buyer kundi the agent. The agent receives the goods as goods of the principal who retains the ownership. For the second difference, the buyer, of course, being the owner, pays the price. Okay? Pays the price. But on the other hand, the agent does not pay the price. Instead, the agent merely delivers the price he got from the buyer. Okay? The buyer, and third one, the buyer as a general rule cannot return the object sold. Of course, you can only return if there are defects or if the goods are unacceptable and they are way different from what was offered. Okay. On the other hand, agent can return the goods in case he is unable to sell them. Okay. So those are the difference between contract of sale and contract of agency to sell. Another addition in a contract of sale, the parties are the seller and the buyer, diba? The vendor, the vendee. Dito naman kasi, the parties is what you call the principal and the agent. Principal, siya yung party na nire-represent ni agent. Siya yung nagbebenta. Si principal talaga yung nagbebenta. Siya talaga si seller. Okay? Si agent, siya lang yung nagre-represent kay seller para maibenta niya kay buyer. Yeah. Para makita niyo yung buong picture ng contract of agency to sell. Article 1467, a contract for delivery at a certain price of an article which the vendor in the ordinary course of his business manufactures or procures for the general market, whether the same is on hand at the time or not, is a contract of sale. Ito na yung diniscuss natin before, the difference between contract for a piece of work versus the difference between a contract of sale. Diba? But if the goods are to be manufactured especially for the customer and upon his special order and not for the general market, it is a contract for a piece of work. Diba? Ang tanong nga lang dyan, if the thing or the determinate object is number one, it is not in existence. Ibig sabihin, it does not exist. Number two, which would have never existed but for the order of the party desiring it. Diba? Ibig sabihin, it will never exist. Okay? Wala sa product list niya, wala sa listahan niya ng mga in-offer niya. Okay, then that is a contract for a piece of work. If it's given especially by the buyer, specially requested, wala sa stocks, okay, then that is a contract for a piece of work. This one we have discussed actually na before. Okay, we're just seeing the legal basis. Okay? Contractor is a person who, in the pursuit of independent business, undertakes to do a specific job or piece of work for other person using his own means and methods without submitting himself to control as to the petty details. The test in determining whether one is a contractor or not is the control of the employer. The control of the employer shall only be the result. Gaya nung example natin before, nagbigay siya ng detail ng table na gustong ipagawa niya. Okay, kung ano yung build, kung ano yung design. Ito lang yung nasa control ng employer. Okay? Hindi niya na alam kung paano yan gawin. Kasi yung kung paano yan gagawin is nasa contractor na. Okay, the means of which is achieved is not within the control but in the contractor's part. Okay. 1468. If the consideration of the contract consists partly in money, partly in another thing, the transaction shall be characterized by the manifest intention of the parties. Dito muna tayo sa una. Kasi madaming malilito dito. If partly in money siya, and partly in thing, sabihin, I sold my cell phone, and the buyer paid me 5,000 cash, and the other is 5,000 worth of an old cell phone, sabihin mo na lang din. Ano ang rule? It will depend on the intention of the parties, manifest intention of the parties. That is the first rule. Okay? If the intention is not clear, then if the thing is is of much value than the money, it is a barter. But if the thing is lesser in value or equal to the money, it is a sale. Actually, this one is the third rule. Okay, that is the rule. With regards to whether one is a barter or a sale, this is the rule. The first rule, when it's partly in money and partly in thing, the rule is not barter or sale, but rather the intention of the parties. Meaning, basahin mo yung facts ng case. If sinabi nila doon na it is a sale, it is a sale. Okay, kahit pa mas malaki yung value ng property. Okay? Pero kung wala kang makita sa facts, and you can justify that, okay, proceed ka na sa second rule. Kung mas malaki yung thing, it's barter. Kung parehas, or mas malaki yung money, it's sale. It is a sale. Okay, that's simple, very simple. Yan, partly in money, partly in thing, intention of the parties. If intention is not clear, things greater than money, barter. Intention not clear, thing is less than or equal to money, sale. Okay? In order that the price, now let's proceed to the price. As to the certainty of the price. Okay? In order that the price may be certain, it shall be sufficient that it is so with reference to another thing certain. Take note, paano mo masabi na certain ng price? Number one, it is with reference to another thing certain. Let's say, for example, iPhone 13. Okay, the price of my phone, which is not an iPhone, may be of the same price as with an iPhone 13. Okay, as long as it has reference with another thing that is certain. Okay, and then the determination. Say for example lang, I own a Samsung phone and I want to sell it. And it's currently, kahit hindi totoo example lang, and I want to sell it for a price that is the same as the iPhone 13. Then that could be a price that is certain. Okay? That the determination thereof be left to the discretion to the judgment of special persons or persons. Okay, the price may also be determined by a special person or persons. Pwedeng isang tao, third party, or a group of third persons. Okay, pwede. As long as they will decide on it. Should such person or persons be unable or unwilling to fix it, the contract shall be inefficacious. Ibig sabihin, no effect unless the parties subsequently agreed upon the price. Take note, this rule is in complementary with the rule that the parties may set their prices. Okay, the parties themselves can agree on the price. Diba? Let's say for example, the seller offers a price, then the buyer agrees with the price. That is a perfected contract of sale. Okay? Ito lang kasi 1469 in cases wherein the parties don't want to determine the price. Sabihin nila, will depend the price on the price of this iPhone 13. If kung magkano yan, then that will be the price of the sale. Gets nyo? Yes, like that. Or, we will assign the barangay captain to determine the price. Okay, pwede. Or the whole barangay. Pwede. Okay, but if they will not be able to set the price or determine the price, then it will be ineffective. Okay, unless the parties themselves agreed. Okay? If the third persons or itong special persons na to acted in bad faith or by mistake, the courts may fix the price. Where such third person or persons are prevented from fixing the price or terms by fault of the seller. Yung kanina, there is bad faith, there is mistake, therefore the courts may fix the price. Dito naman, of course, the courts may fix the price. But, ito kasi, ang nangyari kasi, if, let's say for example, si barangay captain ang pinili nyo na mag-set ng price, pero ang ginawa nung either si seller or buyer is pinigilan si barangay captain para hindi niya ma-set yung price. Okay? The party not in fault may have such remedies against the party in fault as are allowed the seller or buyer as the case may be. Okay? Meaning, let's say for example, diba si barangay captain, mamaya hinarang siya ni seller kasi gusto ni seller itaas niya yung price. Okay? Pag ito nalaman ni buyer, the party not in fault, party not in fault, ibig sabihin, siya yung walang ginawang masama dun sa transaction. Okay, pwede siyang magkaroon ng remedies against kay seller. Gaya ng damages. Damages or pera yan. Ang damages sa batas is pera. Ibig sabihin, kung magkano yung sinet ni barangay captain, plus yung damages, pwedeng singilin ni buyer. Okay, imbes na makakasingil sana si S, baka magbayad pa siya or baka wala na siyang masingil kay buyer dahil sa ginawa niyang pangaharang kay barangay captain. So that is the purpose of that paragraph. Okay? If the parties cannot agree, they can refer the price to another thing that is certain. Okay, iPhone 13, Samsung 21, as long as the price is certain. Okay, pwede yun. Doon sila magbe-base. Kung anong value niyan, that could be the value of our that should be the value of our contract. Or pwedeng i-left sa judgment ng third person or third persons, hindi lang isa. Okay? Basta kapag hindi nila yan na-fix, ineffective unless we agree. Okay? If may bad faith or mistake on the part of the third persons, special persons, the court may fix the price. If haharangin ng isa or ipiprevent ng isa yung third person mag-fix ng price, then therefore, you can file a case against him. You can have a remedy against him. Okay? Requisites of a valid price. Number 1 is that it must be real. It is not simulated or not fictitious. Diba sabi natin noon, kapag simulated ang price, walang price talagang binayaran, nasa papel lang. Okay? Dapat mayroong price. It must be real. It must be certain. Okay, either with reference to another thing or determination of third parties, or in money or in money or its equivalent. Okay, and manner of payment must be agreed upon. Manner of payment, diba? This one I have not emphasized this more than enough, diba? Even if you have agreed on the price, if you have not yet agreed on the manner of payment, there is no consent. Diba? Diba? Because you must have consent with regards to the object and the price. Diba? Kung walang consent, walang perfection, walang contract of sale. Okay? Those are the 4 requisites of a valid price. Article 1470. We have also discussed this one before with regards to gross inadequacy of price. Diba, in an ordinary sale, gross inadequacy of price will not automatically invalidate a sale. Does not affect a contract of sale. Yeah. Except as it may indicate a defect in the consent or that parties really intended a donation or some other act or contract. Take note, mere alleged inadequacy of a contract does not make the contract of sale void. It may only indicate a defect in consent or some other contract. Unless the price is grossly inadequate or shocking to the senses or the conscience, the sale is not set aside. Okay? You can invalidate a contract of sale because of inadequacy of price, but that inadequacy of price must be gross. Must be gross or must be shocking to the conscience. Okay? S sold this 5-year-old car for 500,000, not knowing that the fair value is 650,000. Is the sale valid? Yes, the sale is valid. Mere inadequacy of price does not invalidate a contract of sale. Okay? The inadequacy in price should be gross or shocking to the conscience in order for it to be declared as an invalid. In this case naman, hindi. Okay, 150,000 difference. Okay, it's not gross. The difference is not gross. It's not shocking to the conscience. Okay? Ayaw na mag-next. 1471. If the price is simulated, diba? The price is simulated or fictitious or fake or walang price talaga, the sale is void. But the act may be shown to have been in reality a donation, some other act or contract. Pero pag sinabi mo kasing donation, it must meet the requirements or the requisites required for a valid donation. Okay? Hindi naman parehas ang contract of sale sa donation. It has different requirements. Okay? Bastang tandaan nyo, if the price is simulated, the contract of sale is void. Okay? A contract of sale becomes binding and valid contract upon the meeting of the minds as to price. Okay, a contract of sale becomes binding and valid contract upon the meeting of the minds as to price. Okay, if there is no meeting of the minds as to price because the price is simulated, then the contract is void. Okay, so how do we say that the price is how do we say that the contract is void? Yeah, it is void because first one, the price is simulated. The second reason is that there is no meeting of the minds as to the price since the price is already simulated. Okay, payment of the price is failure to pay the price is failure to pay the consideration. Take note guys, iba yung simultaneous yung price, iba yung simulated yung price, iba naman yung hindi mo nabayaran yung price. Okay? Simulated price, merong price na nakalagay sa contract, pero in reality, there is no price to speak of. Walang na-receive, walang binayaran, walang exchange, basta nag-exchange lang ng property. Walang transfer lang ng property. Parang donation lang. But, if merong price sa contract, pero you failed to pay the price, that is different story. Iba yung lack of consideration sa failure to pay consideration. Lack of consideration or lack of yung absence of price is not the same as failure to pay the consideration. Okay? Itong lack of consideration kasi ito yung dito. Kasi walang price na, kasi simulated yung price. Kapag failure to pay the consideration, the price is real. Yun nga lang, hindi mo lang nabayaran yung consideration or yung price. Okay? Just for your thoughts kasi there are problems argued in that way na because there is failure to pay the price, sasabihin na there is a simulated price. Okay? Take note that in the court, you are arguing with a lawyer. Okay, parehas kayo ng pinag-aralan. Of course, meron din siyang defenses, meron din siyang arguments for you. Depende kasi sa sinasabi ng client niya. Okay? Kaya ganun ang nagiging nangyayari. Okay, so they may argue that way. That since no price was ever received by my client, wala kayong pinakita acknowledgement receipt, walang proof to show that there is really a price that has been given, then therefore, the price is simulated. The price is fictitious. Therefore, the sale that you are saying that is present in this case is void. O, di ba? Di panalo sila. Walang, sabi nila, fictitious daw yung price. Kaya, okay, ganun sa court. R is the owner of a lot in 1981. R sold the lot to H. R alleged that in 1984 she signed a deed of sale in favor of M. So R sold the lot to H. R alleged that he sold the lot to M. R being illiterate, signed by a fixing term. M promised to pay $47,000 purchase price within 1 month. No payment was made. R made a demand and revoked the sale. M, however, sold the lot to H. Is the sale between R and M? That's why it's very important to do this in your problems. Kung pwede nyo ma-adapt. Because why? Ang bottom line kasi ng problem is the question. Is the sale between R and M valid? Anything that happened here may or may not have anything to do with your answer here. Is the sale between R and M valid? Tignan, nandito tayo sa price. So, dito, the facts are lacking. Okay, why? Because masyadong madaming wala. I think the answer will provide yan. Based on the evidence presented, the trial court found that M never paid to R and R never received from the purchase price, meaning the price is simulated. Therefore, kaya ang sabi niya kanina, the sale is void. Okay? Where the deed of sale states that the purchase price has been paid, Sabi kasi nabayaran yung purchase price, but in fact has never been paid. The deed of sale is null and void ab initio for lack of consideration. That's why they said the sale is void. You can adapt this reasoning if you are confronted by this question. Okay? The sale is void. The sale is void for lack of consideration or lack of price. Naglag na naman siya. 1472. The price of securities, grains, liquids, and other things shall also be considered certain when the price fixed is that which the thing sold would have on a definite day. Okay, yung price nitong securities, grains, liquids, and other things can also be considered certain when the price fixed is that which the thing sold would have on a definite day. Let's say for example, ang sabi nila, sige itong ano kaya gaya ng mga gulay-gulay, mga grains, mga liquids. Okay, let's say for example, ibebenta niya on a definite day. So the price of that gulay on a definite day could be the price of this gulay. Okay, ganun kasi usually sa market. Okay, or in a particular exchange or market. Okay, in a security or in a stock or securities exchange market. Diba? Sa PSE index. Okay? So, kung ano yung nakalagay doon na price, then that could be a certain price. Okay? When an amount is fixed above or below the price on such a day, pwede siyang maging certain. Okay? Provided said amount be certain. Okay? 1473, the fixing of the price can never be left. This one we have already discussed na rin before. Diba? Can never be left to the discretion of one parties. Except, however, if one of the parties accepted the price offered by the other, then the sale is perfected. This one we have discussed. Where the price cannot be determined in accordance with the preceding articles, the contract is inefficacious. However, if the thing or any part thereof has been delivered to and appropriated by the buyer, he must pay a reasonable price thereof. What is a reasonable price is a question of fact dependent on the circumstances of each particular case. Okay, take note, if the price cannot be determined, it is inefficacious, meaning it is void. But if the price cannot be determined, but the buyer has already received, or the seller has already delivered the property na received na ni buyer. Okay? Inappropriate na ni buyer. Ibig sabihin ng inappropriate, inangkin niya na sa kanya na, siyempre na-receive niya na eh. Hindi ba determine yung price? Anong gagawin? Dapat magbayad pa rin siya, di ba? Yung nasa obligation siya. Kung balikan yung first na article, nandun pa rin. To pay a price that is certain. Ang sabi dito, since you have already received the property, you have already appropriated it under your name, you must pay a reasonable price. Okay. What is reasonable price is a question of fact. When we say question of fact, depending on the circumstances or the facts presented. Okay, when we have cases like this, usually invoke the court, or you can mediate or settle things to determine a reasonable price. Of course, what is reasonable price? Okay, that is offered by the buyer may be contested as to the accuracy of the price. Okay. The contract of sale is perfected at the moment there is meeting of. This one we have also discussed, di ba? The contract of sale is perfected the moment there is meeting of the minds on the object and the price, di ba? Paulit-ulit to. From that moment, the parties may reciprocally demand performance. Meaning, upon perfection of the contract, the parties may reciprocally demand performance, subject to the provisions of the law governing the forms of contracts. Unless, of course, meron kayo nakalagay na date kung kailan magbabayad o kailan de-deliver yung property, then that should be followed. Yun yung agreement nyo eh. Take note, under obligations and contracts, I'm referring about obligations and contracts because contract of sale is under obligations and contracts. Okay? The contract, the agreement of the parties will prevail as long as it is not contrary to law, morals, customs. Okay? It will prevail. If walang nakasaad, then i-follow natin yung nasa law. Okay? So, the parties may reciprocally demand performance from the time of the perfection. Take note, ang determine natin dito is at the time of perfection. Kaya ang lagi nyo dapat nasa sa utak nyo is the sale perfected? Lagi yan. Is the sale perfected? Meaning, meron na bang consent, object, consideration? Okay? If meron na lahat yan, perfected ang contract. Merong contract of sale. Therefore, the parties can demand. Okay, you have the example here. Y Corp sent a letter proposal for the delivery and sale of its products to be installed at various offices of X Corp. X Corp later accepted the proposal and issued the purchase order. Thereafter, Y Corp delivered the said products. After delivery, Y Corp demands payment from X Corp, but the latter instead returned the products to the agent of Y Corp. Should X Corp pay the price? Based from that example, dapat yes, diba? Yes, because X Corp already accepted the proposal and it also issued the purchase order which prompted Y Corp to deliver. Okay, so si Y Corp ginawa niya na yung part niya to deliver. Okay, should X Corp pay the price? Yes, you should pay the price. A contract of sale has been perfected at the precise moment X Corp, as evinced by its act of sending Y Corp the purchase order, accepted the letter's proposal, o diba, tama yung sabi ko, to sell the products considering the purchase price. From that point, the reciprocal obligations to the parties, Y Corp to deliver the said products to X Corp and X Corp to pay the purchase price, is already enforceable. Okay? So take note, from the moment that there is perfection, then that is the time that it is reciprocally demandable. Dito, Y Corp sent a letter proposal, nag-offer siya. Si X Corp naman, he accepted it. Okay, offer and acceptance. Okay, there is meeting of the minds. Therefore, it's already perfected. Diba? In the case of sale by auction, di ba ito na kwento ko na rin yung sale by auction before in case of foreclosure sales or properties that are sold by auction. Okay? Meaning yung merong nagbabang ng gavel or ng hammer, diba? Yung going once, going twice, in-offer sa public. Okay, sale of a cell phone, diba? Going once, going twice, sold, diba? Going once, pag may nag-bid, bid for the amount of this one, bid, hanggang sa wala nang mag-bid. The highest bidder wins. Okay? Where goods are put up for sale by auction in lots, if it's in lots, Each lot is the subject of a separate contract of sale. Of course, this is very basic in an auction sale. Usually, ito naman kasi ang fina-follow. Auction sale is usually conducted in lots. Okay? So, every lot is a separate contract of sale or deed of sale. A sale by auction is perfected. Take note, itong auction sale or sale by auction is different from an ordinary sale. An ordinary sale kasi, there is a seller, there is a buyer who came together, who have agreed as to the object and to the price. From that moment na nag-agree sila, there is already perfection. Dito kasi sa sale by auction, it is perfected when the auctioneer announces its perfection by the fall of the hammer. Diba? Perfected siya pag last bid is worth $1,000 or 1,000 pesos. Going once, going twice. Kung wala, bag, sold. So, perfected yung contract. Ganyan sa sale by auction. Or in other customary manner, yung iba pito, ganun. Another customary manner. Until such announcement, so kapag wala pa yung announcement, or hindi pa nag-bang yung hammer or yung gavel, hindi pa nagpito or any customary manner, any bidder may retract his bid. Okay? Kung nagdalawang isip ka, gusto mong bawiin yung bid mo, you can retract your bid. The auctioneer may withdraw the goods from the sale unless the auction has been announced to be without reserve. This one is when the goods are announced to be without reserve. Okay? A right to bid may be reserved expressly by or on behalf of the seller, unless otherwise provided by law or by stipulation. A right to bid may be reserved expressly by or on behalf of the seller. But, take note, this operates on a notice. Where notice has not been given that the sale by auction is subject to a right to bid on behalf of the seller. Meaning, ito kasi mga in-auction, di ba? Alam na si seller ang bibili din. Si seller din ang magbebenta, ang magkikinabang, di ba? Kaya nga yan binid kasi hindi siya makabenta tapos siya ang magbibid. Usually, hindi pwede yun unless there is notice. Kung walang notice, it shall not be lawful, meaning unlawful. Hindi pwedeng makibid si seller, hindi rin siya pwedeng magpadala ng agent niya na magbibid in behalf of sa kanya. Okay? Or to employ or induce any person to bid at such sale on his behalf. Okay? Kapag walang notice. Kapag may notice, then pwede siyang magbid. Okay? Kung walang notice, hindi pwede. It's not lawful. To employ or induce any person to bid at such sale on behalf of the seller or knowingly take any bid from the seller or any person employed by him. Any sale contravention may be treated as fraudulent by the buyer. Okay? Take note of that. The ownership of the things sold shall be transferred to the vendee upon the actual or constructive delivery thereof. Take note, ito na yung tradition na sinasabi natin. You acquire or you transfer ownership by delivery. The ownership of the thing sold shall be transferred, di ba? Sabi niya. The ownership of the thing sold shall be transferred to the vendee upon actual or constructive delivery. Sir, paano actual? Kung personal property yan, when I say personal property, lahat ng property na pwede mong ilipat. Movable property. Movable property. Movable. Lahat ng pwede mong idala, ilipat. That is personal property. You deliver that or you transfer ownership of that by what we call actual delivery. Okay? Kasi nga, yan, bigay ko sa iyo, yan. Actual delivery. When we say constructive delivery, this one usually in the form of, let's say for example, keys of a car, diba? Keys, susi. Hindi yung sasakyan mismo bigay mo. Although you can deliver the car with the key. Okay? Or the title of a lot, yung titulo ng lupa. Hindi mo naman de-deliver yung lupa mismo, diba? Unless kaya mo. Kung kaya mo. Okay? But it is the title, constructive delivery. Okay? Hindi yung thing mismo, the title, or the representation, or the evidence of ownership. It is when delivery that the vendor loses ownership. That's why it is with delivery that the vendor must be the owner or must have the right to deliver. Dapat dyan sa delivery talaga. The failure of the buyer to pay the purchase price in the stipulated period does not by itself bar the transfer of ownership or possession or ipso facto rescind the contract. Okay? Basta na deliver, there is a transfer of ownership, whether it be actual or constructive. The vendor has the option to rescind the contract of sale judicially or by notarial demand. If the seller has already transferred or delivered the property and the buyer fails to pay, fails to pay, then ang gagawin ni vendor, he can rescind the contract in court, judicial, rescind the contract in court, or by notarial demand. Okay? But the parties also may stipulate that ownership in the thing shall not pass to the purchaser or buyer until he has fully paid the price. They must also agree with this. Just like a contract to sell. Even after delivery, the seller... I have discussed this actually. There is a difference between contract to sell and contract of sale. Diba? I have discussed this one. A promise to buy and sell a determinate thing for a price certain is reciprocally demandable. Okay? Bagalan natin. A promise. What promise? To buy and sell a determinate thing for a price certain is reciprocally demandable. An accepted unilateral promise to buy or to sell a determinate thing for a price certain is binding upon the promisor if the promise is supported by a consideration distinct from the price. So this one when both promise to buy and sell a certain thing, it becomes reciprocally demandable. But if it's a unilateral promise, this is what we call the option contract. Diba? We have also discussed this one. Okay? We have also discussed this one. Diba? It's a promise to buy or to sell a determinate thing for a price certain, provided there is a consideration that is distinct from the price. Diba? This is what we call the option contract. Most contracts have lease with option to purchase. Meaning, they will lease the property and the lease payments or the monthly rental payments shall form part of the purchase price. May mga ganun. The option to purchase. Okay? A unilateral promise to buy or sell is a mere offer, which is not converted into a contract except the moment it is accepted. Acceptance is the act that gives life to a juridical obligation, because before the promise is accepted, the promisor may withdraw it at any time. Of course, if it's a unilateral promise, meaning ikaw lang na nagpa-promise, hindi naman in-accept ng isang party, there's no juridical relation, there's no juridical obligation on the part of the promisor or on the part of your or on your part na ikaw dapat mag-accept kasi hindi mo in-accept. Okay, but if it's a unilateral promise with a consideration, may presyo, gaya ng isang option contract, and the other party accepted the consideration, then that is an enforceable obligation, a juridical obligation. Any injury to or benefit from the thing sold after the contract has been perfected from the moment of the perfection of the contract to the time of delivery shall be governed by 1163 to 1165 to 1262. We'll talk about that. This rule shall apply to the sale of fungible things made independently and for a single price or without consideration of their weight, number, or measure. Should fungible things be sold for a price fixed according to weight, number, or measure, the risk shall not be imputed to the vendee until they have been weighed, counted, or measured and delivered, unless the latter has incurred in delay. Sinasabi lang dito, ang point out ko lang sa inyo is this one. An injury to or benefit from the thing sold from the time of perfection to delivery. Lahat ng nangyayari from the time of perfection to delivery shall be governed by Articles 1163 to 65 and 1262, which means if yung object nawala before perfection, so ibig sabihin wala pang meeting of the minds, wala pang na-perfect kasi. Therefore, si seller pa rin ang may-ari. Therefore, seller bears the loss. Siyempre, wala pang perfection eh. Seller pa rin may-ari. Diba? Object is lost after delivery to the buyer. Diba ang sabi natin kanina, delivery transfers the ownership. So, kung tinransfer na sa buyer bears the loss. Meaning, kapag nawala yung property after delivery, si buyer na ang mawawalan. Wala nang responsibility seller. Unlike before perfection, si seller bears the loss. Okay? Because it happened before perfection, before delivery. Okay? If the object is lost after perfection, so na-perfect na, there is already meeting of the minds. But before delivery, buyers bears the loss. Why? Because the buyer already expects that that thing be delivered to him, di ba? The buyer already expects. This is the principle of Resperit Domino. Okay? Whoever is the owner bears the risk of loss. Okay? Whoever is the owner bears the risk of loss. Kung mawala yung property, sa kanya ang risk. Okay? So, take note, those are the rules that I want you to focus on. Kung before perfection, walang meeting of the minds, si seller pa rin kasi hindi naman nag-transfer yung ownership. Kung nag-transfer na yung ownership, there is delivery, si buyer na. Okay? Ang mag-bear ng risk of loss. Meaning, kapag nawala ni buyer after delivery, hindi niya pwedeng balikan si seller. Na-deliver na eh. Diba? Ganun yun. Object loss after perfection but before delivery, buyer bears the risk of loss. Okay? Fungible goods interchangeable with one another. Yan yung fungible goods. Goods that by nature or trade usage are equivalent of any other like unit such as coffee or grain. The sale of a specific mass of iron ore for 75,000 without specific weight, measurement, or number of tons or units is valid. All the seller has to do is deliver all the ore found in the mass. This one is related to what we have discussed regarding specific weight or mass, di ba? Yung 300 sacks, 100 sacks. Article 1481. Bear with me, please. In the contract of sale of goods by description or by sample, the contract may be rescinded. Kapag sinabi natin rescinded, guys, it may be cancelled. Rescinded, cancelled. If the bulk of the goods delivered do not correspond with the description or by sample. And if the contract be by sample as well as description, it is not sufficient that the bulk of goods correspond with the sample if they do not also correspond with the description. Tatlong sale ang kino-contemplate nitong article na ito. The first one is sale by description. The second one is sale by sample. The third one is sale by description and sample. Okay? Meaning, if it's sale by description, then the property sold should be in conformity with what has been described. If it's by sample, then it must be in conformity with what has been shown to you as a sample. If it's description and sample, it must be both by description and by sample. Okay? The buyer shall have reasonable opportunity of comparing the bulk with the description or the sample. Diba? Gaya nung, let's say for example, yung nag-manufacture ng furniture noon, yung table. Diba? Merong product list, may menu, andun yung kung by sample siya or by description, andun yung description or yung sample. Dapat it must be in conformity with the specifications of the product. Diba? If not, there could be actions. And what are the actions? Kapag hindi siya nag-comply dito, it may be rescinded. Diba? Sabi namin kanina, the contract may be rescinded. Okay? Take note of that. Whenever earnest money is given in contract of sale, it shall be considered as number 1, part of the price, and number 2, proof of the perfection of the contract. So earnest money is part of the price and proof that the contract has already been perfected. So pag may earnest money, perfected yung contract. Yun yung basic logic dun, basic thought. It is also called an aras. It is given to show good faith to complete the transaction and forfeited if the buyer defaults. Okay? X offered to buy the lot of H. H agreed to sell the land. X then gave 100,000 as partial payment. So, nagbayad siya ng partial payment. Thereafter, X offered to pay the whole amount of the purchase price. However, H returned the 100,000 to X's counsel due to his decision to leave for abroad. Is the 100,000 an earnest money? If we are going to stick with this problem, of course, sabihin natin, it is X already gave 100,000 partial payment, therefore that is earnest money. Pero this one kasi I think meron siyang facts na hindi disclose. Ayan, meron nga. Receipt of partial payment contains received from X the amount of 100,000 partial payment to my lot. X promised to pay the balance of the purchase price on or before March 1990, and that, take note of this, I will execute and sign the final deed of sale on this date. What does this indicate? This indicates that there is no contract of sale yet. Diba ang sabi ko before, when it comes to the sale of a land, ang ginagawa dyan, contract to sell. Wherein, may promise to sell on the part of the seller upon full payment of the purchase price ni buyer. Kapag nabayaran na ni buyer yung full purchase price, then the seller and buyer will execute what we call an absolute deed of sale or a contract of sale. In this case, this shows that the agreement is a contract to sell and not a contract of sale. Therefore, the 100,000 is not an earnest money. Hindi siya earnest money. Why? There is no earnest money in a contract to sell. Walang earnest money in a contract to sell. Why? Because a contract to sell is not a contract of sale. In a contract to sell, there is no perfected contract. It lacks what? It lacks consent. Diba? Nandiyan lang, promise to sell lang. Okay? Ayan. Article 1482 speaks of earnest money given in a contract of sale. In this case, the earnest money was given in a contract to sell. The earnest money forms part of the consideration only if the sale is consummated upon fulfillment of the purchase price. Now, since the earnest money was given in a contract to sell, Article 1482 does not apply. Diba? That's why it's very important to read the law and understand it for what it is. Ayan siya. Whenever earnest money is given in a contract of sale, so pag na-miss mo yan, you can be wrong in your answers. Why? Because we only talk about para madali, we only talk about earnest money when there is a contract of sale. Because sabi nga natin, it's a proof of the perfection of the contract. Therefore, if it's not a contract of sale, it is a contract to sell. Kung contract to sell yan, therefore, we're not talking about earnest money. Okay? Then what are we talking about, attorney? We're talking about this compliance to the contract to sell. Okay? Ganyan kasi ang contract to sell. As a protection na rin kay seller na hindi mawala lahat ng properties niya. Okay, why? Because if you already executed the contract of sale habang nagbabayad pa siya, paano kung na-transfer na yan sa lupa niya, hindi niya siya nakapagbayad, hindi kawawa si seller. Ganun siya. Kaya ang execution ng contract of sale is sa last part or sa kapag nagbayad na ng buo. That is very, the transaction in the real world. Okay, contract to sell siya. I believe we have another problem is X offered to buy the lot of H, W, and K. H did not accept the offer as he has still to get the approval of CB. X then deposited 100,000 check as payment. Thereafter, X demands to proceed with the sale of the property. Is there a perfected contract? I think you can already answer that is no. There is no perfected contract of sale. As between the parties, there is no sale to speak of. Tama. And there is merely an offer by one party without acceptance of the other. There is no contract, diba? Based from the problem kasi there was no acceptance. In the parties never got past the negotiation stage. X therefore has no obligation to make payment, nor did he possess the right to deliver earnest money. There must be a perfected contract of sale before we can speak of earnest money. 1483, subject to the provisions of the statute of frauds and of any other applicable statute, a contract of sale may be made. Take note, a contract of sale may be made in writing, by word of mouth, orally, verbally, partly in writing, partly by word of mouth, or maybe inferred from the conduct of the parties. Okay? So, ang form ng contract of sale is wala. It may be in writing, it may be word of mouth, or oral or verbal, or it may be inferred from the conduct of the parties. Except when the sale of the land or any interest therein is through an agent, the authority of the latter or the agent must be in writing, otherwise the sale is void. Meaning daw, walang form ang contract of sale except when the sale is involving land or any interest therein, involving an agent, which authority must be in writing. And that it must be subject to the provisions of the Statute of Frauds. What is the Statute of Frauds? Ayan, yan ang Statute of Frauds. If the sale of the property, if the sale is of real property, if the sale of personal property at a price not less than 500, so kung kayo nakapagbenta ng personal property, ng cellphone, ng laptop, that is not less than 500 pesos, covered yan. Ano yan? Dapat in writing. Yan ang Statute of Frauds. Sale of property not to be performed within a year from the date thereof. Sale of property not to be performed within a year from the date thereof. Why? Because Statute of Frauds dictates that to be enforceable, they must be in writing. Kasi kung hindi sila in writing, it will be hard for the one enforcing the contract or the instrument to demand performance. Diba? Why? Because first of all, you don't have a proof. And second, Statute of Frauds dictate that it must be in writing, yet you did not put it in writing. Therefore, you're stoked. Okay, pang nagkalokohan kayo at ayaw magbayad, aware ka naman sa Statute of Frauds. Sir, paano kung di ako aware sa Statute of Frauds? No, you're aware. Because under the law, okay, di ba sabi nga natin, ignorance of the law does not excuse anyone. It will not excuse you. Kahit pa hindi mo talaga alam. Okay? Why? Because there's what we call constructive notice, which is not to be discussed. Mahaba pa. Basta ganun. Okay? So, general rule, any contract of sale may be in writing. It may be verbally or orally or inferred from the conduct of the parties, except if the sale involves a piece of land or any interest therein, wherein it was sold to an agent, in which the authority of that agent must be in writing. Okay, kung hindi in writing, the sale, kahit pa may nangyaring sale, may be voided. Okay, ano pa ang kailangan na in writing? Sale of real property, sale of personal property above 500 pesos, sale of property not to be performed within a year from the date thereof. Diba? Sobrang importante din naman kasi yan. Not to be performed from within a year from the date thereof. Paano kung magkalimutan na? That's why it's important to have this in writing as protection. Okay? As protection and as a tool for you to enforce the contract. If not, the sale may be valid, but it is not enforceable, unenforceable. Di ba? Balik kayo sa obligations and contracts, unenforceable contracts. Di ba? Ang exception lang naman sa unenforceable contracts if it is partially complied. Di ba? Of course, you must show proof that that obligation or that contract has been partially complied. Diba? Then you can enforce it even if it is against the Statute of Frauds. Okay? 1484, yan, malapit na tayo. In the contract of sale, so take note, this is in a contract of sale. Anong binibenta? Personal property, the price of which is payable in installments. So, i-apply natin sa Article 1484 if there is a personal property na binebenta and it is sold or payable in installments, the vendor may exercise any of the following remedies. The vendor may exercise any of the following remedies. Number 1, exact fulfillment of the obligation should the vendee fail to pay. Meaning, demand payment from the vendee. Okay? Exact fulfillment of the obligation should the vendee fail to pay. Okay? So, walang nakalagay dyan. As long, kasi ito installment, di ba? Kung 12 months, kung 12 months yan, 12 months siyang magbabayad. Okay? So, first month, second month, 12 months yan. Pag may na-miss siya, the vendor daw can exact fulfillment of the obligation should the vendee fail to pay. Okay? The second one, cancel the sale or rescind the sale, cancel the sale. Should the vendee fail to pay 2 or more installments? Take note. Should the vendee fail to pay 2 or more installments? So if the vendee fails to pay only one installment, you cannot use this remedy. Okay, you can only use this remedy if the vendee failed 2 or more. Okay? Kung isa pa lang yan, pwede itong exact fulfillment. The third one, foreclose the chattel mortgage. Diba? Since this is a personal property, para hindi kayo malito. When we talk about personal property, ito yung tinatawag nating movable property. Diba? You can move them. They are accessible. You can move them. Just as simple as that. Okay, wala naman tayo sa property. Okay? Kapag mortgage sila yan, ang tawag dyan, chattel mortgage. Unlike real property naman immovable. Immovable meaning hindi mo ma-move. Yan yung lupa, bahay, building. Ayan. Ang tawag naman sa mortgage dyan, real estate mortgage. Okay? Magkaiba kasi yan. Kapag nakarinig kayo ng chattel mortgage, ang subject niyan is personal property, which is this one. Foreclose the chattel mortgage on a thing sold if only one has been constituted, should the vendee fail to pay 2 or more installment. So take note, under the second and the third remedy, okay, dapat 2 or more failed payments of installment. Okay? Kung isa lang, hindi mo pwedeng cancel yung sale, hindi mo pwedeng foreclose yung chattel mortgage. Okay? Ano lang pwede mong gawin? Exact fulfillment of the obligation. Demand payment of the obligation. Yun lang. Okay? Kung nakadalawa na siya, ayun, pwede. Cancel and foreclose the chattel mortgage. In this case, you shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. Okay, katuloy nitong foreclosure, ito kasing chattel mortgage, kapag ginawa siyang collateral, ganun, gaya ng sasakyan, kapag binili, siya mismo yung collateral. Okay, kapag na-foreclose yan, di ba yung foreclose na tawag natin sa foreclosure sale. Di ba, binibenta siya through auction. Okay, let's say for example, the original price of the car is worth 1 million pesos. Pero nung nabenta siya sa foreclosure sale, nabenta lang siya in the amount of, let's say for example, 700,000 pesos. Okay. The seller, mayroon pang 300. Siyempre, ikaw na nagpautang dun sa buyer, siyempre gusto mo mabawi yung kulang mo. But no, the seller can no longer recover this 300,000 because you already went with the foreclosure. Okay? Kasi kung ano ang mabenta mo, kung anong price niyan, nabibenta yung property, yun na yung makukuha ni seller. Okay? Kapag may kulang, hindi niya na makukolekta. Okay? Sabi dito, in this case, he shall have no further action against the purchaser to recover any unpaid balance of the price. So kung 1 million yung pinangutang niya noon, and nung nabenta yung property by foreclosure sale, kulang pa siya ng 300,000, hindi niya na makukolekta yun. That's what the law says. Okay, because of depreciation, ganun din siguro. Okay, that's what the law says. So, if the property sold is a personal property, movable property, and it's paid in installments, this is the rule that you will apply. Okay? Exact fulfillment of the obligation if the vendee fails to pay. So, kahit isa lang yan. To cancel the sale if the vendee fails to pay 2 or more installments. Foreclosure, the vendee fails to pay 2 or more installments. Okay? Tanong, can you use all these remedies para makolekta mo lahat? No. You can only pick one. Okay? So, pag kinancel mo na yung sale, wala nang recovery. Okay? Kung foreclose mo na, pinabenta mo, auction, hindi mo na makancel yung sale. Okay? It's an alternative remedy. Okay? Hindi siya exhaustible remedies na you can select everything. You can enforce everything, every remedy. No. It is alternative, only one. Pick only one. Kung ano yung na-pick mo, then yun ang gagawin. Okay? The preceding article shall be applied to contracts purporting to be leases of personal property with option to buy when the lessor is deprived the lessee of the possession or enjoyment of the thing. Okay. Yung article kanina discuss natin also apply to leases of personal property with option to buy. Okay. In this case, a stipulation that the installments or rent the stipulation that the installments or rent paid shall not be returned to the vendee or lessee shall be valid insofar as the same may not be unconscionable under the circumstances. So, di ba ang sabi ko kanina yung lease with option to purchase, ayan din yun, lease with option to buy. Meaning, the rental payments shall be treated as installment payment. Therefore, if may na-miss siya na isa, pwede yung exact fulfillment of the obligation. Itong diniscuss natin na 3 remedies. Kasi it refers to the preceding article. Okay? Kapag 2 or more installments, yung hindi niya nabayaran, either you cancel the sale or you foreclose. See? The expenses for the execution and registration of the sale shall be borne by the vendor unless there is stipulation to the contrary. Of course, the expenses for the execution and registration of the sale shall be borne by the vendor. That is what is under the law. Okay? Kung walang nakalagay sa deed of sale, sa contract, then the vendor shall be responsible. Pero kung may nakalagay, unless, sabi niya dito, there is a stipulation to the contrary, meaning, baka nakalagay doon, si vendee or si buyer ang bahala sa execution and registration, then pwede lang. That's allowed. Mga obligations and contracts. The expropriation of property for public use is governed by special laws. This one we will not discuss because ni-remove na ito sa contract of sale. Because this is not really a sale, but an exercise of a government power. Okay? And that government power is what we call eminent domain. Diba? To enlighten you more, itong eminent domain na ito, this is the power of the state to take away your private property for public use. So, an attorney example, ayang mga road widening na lang. Ayan na lang, para mabilis. Road widening. Diba, let's say for example, tabi kayo ng kalsada. Diba, dito mayroon kayong lupa dito. Kung ito is road widening nila, Yan, kung makukuha yung lupa niya dyan, ito yan, kukunin yan ng government. Sir, pwede ba yun? Yes, provided that there is what we call just compensation. Babayaran naman kayo ng just compensation. But, in reality kasi matagal yan. Kasi ko-contest pa yan ng may-ari kung talagang yan ba yung value ng lupa, babayaran for public use. Ganun siya. Okay? So, this is more, this is not in a contract of sale, walang ano dito. Kasi this is for necessity or for public or for government purposes. Okay? The seller really doesn't want to sell this property, but the property is needed for public use. Kaya siya binibenta. Okay? Parang forced buying ng government. Okay? Just to exercise their power of eminent domain. Okay? So I think that is the end of my topic. So I hope you learned something. Okay? Thank you.